The people who should have been protected the most are the ones who ended up exposed, and the people facing serious questions are still hidden behind blacked out pages. This is not opinion. This came out in a live congressional hearing when Dan Goldman pressed the Justice Department and questioned Pam Bondi. The record showed a troubling pattern in the Epstein files. Victims' names that should have been protected were left public at the same time. Documents tied to powerful figures were kept hidden as privileged even when victims offered testimony. The Department of Justice never met with them. So the question is simple. If the system worked as intended, why does protection look backwards? Now let's watch the clip after that. We'll break this down using hearing records and reported facts.
Thank you, Mr. Chairman. Ms. Bondi, I went over to the department yesterday for a couple of hours to review some of the unredacted materials. And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents. An 86-page prosecution memo from the Southern District of New York, and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those 2 documents in unredacted form to members of Congress? Not a complicated question.
Well, I guess it is for you because you have a law degree and those are privileged.
Okay, they're not privileged, but we will discuss that later. I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted, and it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you unredact this?
You were lead counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course. I look forward to discussing this more. Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
No.
I'm
if they're
talking.
not privileged,
quiet.
Don't yell at me. If they're not
Mr. Chairman, would you stop the clock? This is on your time. It's not on Mr. Gomez.
They're not
Even though you used your improper redactions.
You'll like my answer.
To
if we
continue
review them
to
and they're not
protect
privileged,
Time belongs to the member.
we'll be happy to release them.
We'll stop the clock. We'll stop the clock. Time belongs to the member. Go ahead.
Even though you used improper redactions to protect Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. 1 is redacted, 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims. Now, in an interview last week...
How will you tell me that's intentional?
In an interview last week, Deputy Attorney General Todd Blanche...
You can't go off script.
...said that any victim that wants to speak with the department has done so, hopefully. Well, thanks to the incredibly brave people sitting here behind you, we can actually ask them if that's true. Now, would the survivors and victims who are here please stand up one more time? Just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and estimate and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence? All of them. And of those of you, all of you who have reached out, how many of you were denied or ignored by the Department of Justice? All of them. And despite the shameful and despicable efforts by Ms. Bondi and her department to intimidate you, how many of you are still willing to speak to the Department of Justice? All of them. Well, Ms. Bondi, it looks like you have some more witnesses
Gentleman's
to
time has
talk
expired.
to, and I yield back.
We will go to the good gentleman from North Carolina, Congressman Knott.
Thank
May
you.
I have a moment, Congressman?
Yes, ma'am.
Thank you. Here we go. Here's the photograph. This is why he wanted to repeat everything that had been said previously on Epstein. This is his state, New York. You probably don't even know who this is. Wahid Mohammed from Afghanistan.
Yes, because I'm no longer a prosecutor.
Convicted of assault. Wow, he represents New York. Wow, yet he doesn't care about the illegal aliens convicted of crimes. Assault and homicide. No longer a prosecutor, so he doesn't care about his constituents. Here we go. Arson, El Salvador, Miguel Palacios. Fermin Flores Ramales, Mexico, rape.
Let's talk about the 70% of immigrants who are detained without a criminal conviction or arrest.
Stop the clock. Stop the clock. Time belongs to Congressman Knott.
Transparency around the Jeffrey Epstein case is not a new concern for newsrooms. Reuters, the Associated Press, the New York Times, and CBS News have repeatedly reported that a significant portion of documents in this case remained sealed or heavily redacted. According to official guidelines, the Department of Justice is expected to treat victim privacy as a top priority in sexual exploitation cases. That typically means identifying details are redacted by default to protect victims from intimidation, harassment, and further trauma. However, recent reporting has highlighted a pattern that appears reversed in some Epstein-related files. Sensitive information connected to victims was left public, while other sections were fully blocked under claims of legal privilege. Legal experts quoted by Reuters and the Associated Press have emphasized that privilege is a limited protection. It is not a blanket shield. Attorney-client privilege applies only to specific communications involving legal advice, routine prosecution memos, draft indictments, and internal administrative documents do not automatically fall under that protection, especially when lawful oversight is involved. This is where the transparency question emerges. When redaction standards appear inconsistent, public trust is affected. Media analysis has noted that confusion grows when agencies do not clearly explain what is being withheld for privacy and what is restricted for legal reasons. Victim engagement has also been a major focus in reporting. According to CBS News and NPR, federal guidelines recognize that survivors should have the opportunity to voluntarily participate in the investigative process. That participation strengthens evidence and reinforces accountability. In the context of the Epstein case, coverage has repeatedly pointed out that this engagement process has not been clearly visible. This concern did not appear. Overnight, it has been raised before in court filings, and investigative reporting journalists have also noted that when victims signal a willingness to cooperate, agencies take on an added responsibility. Clear communication and outreach become essential to maintaining trust. According to the Associated Press, unintended exposure of victim names in sexual exploitation cases is treated as a serious concern. That is why redaction is meant to function as protection, not merely as a legal formality. This is why questions about a reversed order of protection are not framed as political. They are procedural. News analysis has also addressed the use of privilege. Legal analysts consistently note that privilege must be narrowly applied and clearly justified when agencies invoke it. There is an expectation that the legal basis will be explained in the context of congressional oversight reporting by Reuters and Politico. has explained that disclosure standards for lawmakers are typically broader than those applied to public requests. That is because oversight exists to evaluate policy and accountability, not simply to access information for this reason. Recent scrutiny is not being framed as a single heated moment. Media coverage has described it as an institutional stress test. The test is whether the system can apply its own rules consistently under pressure from the perspective of victims. Reporting has emphasized one key point. Their willingness to cooperate is now part of the public record that naturally increases expectations that engagement processes will become more transparent. None of this determines guilt or innocence. Major outlets have been clear that oversight, investigation, and trial are separate processes. The question here is about procedure, not outcome analysis. From the New York Times and the Washington Post has also highlighted that erosion of public trust in this case did not come only from allegations, but from opaque decision-making. Transparency matters only when it is visible in practice, not just promised. When this issue is viewed through a report-based lens, the focus shifts away from individuals. It centers on standards, what the rules say, and how those rules are applied. That is the core of this issue. A system's credibility is tested when pressure is highest. This question is now part of the news cycle, and its answer will come not from statements, but from documented clarity. If you found this breakdown useful, please like the video, share your thoughts in the comments, and for more calm, record-driven explainers like this, don't forget to subscribe.